Mr. Traynor, I just want to follow up on my colleague's questions and make sure that I understand this. You were asked a series of questions about January 6th, and correct me if I'm wrong because I was not here at the time you were asked those questions, and you declined to go into whether this was an insurrection, the nature of the attack on the Capitol, because you said it might involve a case or controversy that would come before you. Is that correct?
Senator, it did involve cases or controversies. We had people in the District of North Dakota that I believe were charged.
So you felt it wouldn't be appropriate for you here today to discuss your views on what took place on January 6th, is that right?
I stated that what I saw was deeply troubling, Senator. The attacks on law enforcement, any attack on law enforcement should be condemned.
So why are you reluctant to answer questions about what took place on January 6th? On the one hand, and on the other hand, you say judges don't forfeit their First Amendment rights. You feel free to write to a university to tell them who they should hire or not hire, who you're going to hire or not hire. You feel free to immerse yourself in that controversy. But here you won't talk about your views of January 6th.
What happens when a judicial nominee refuses to answer questions about January 6th but previously took a public stance on another controversial political issue? That was the central issue during a tense Senate Judiciary Committee hearing, as a senator challenged the nominee over what appeared to be inconsistent standards. The exchange quickly escalated into a debate about judicial ethics, impartiality, free speech, and whether judges should publicly weigh in on controversial issues. By the end of the hearing, the discussion expanded beyond the nominee himself to concerns about federal prosecutions and leadership within one of the nation's largest U.S. attorney's offices. Let's break down everything.
The nature of the correspondence.
So you feel perfectly free to immerse yourself in that, exercise your First Amendment rights there. But when it comes to asking you basic questions about January 6th, you won't answer those questions.
The difference, Senator, is that there are cases or controversies that I have before me as a district judge relating to individuals that have been charged for conduct that occurred on that date in this Capitol.
So does that mean that any litigation involving Columbia you're prepared to recuse yourself from?
Senator, the limitation on Columbia was in regard to hiring law clerks. I hold no bias against the institution itself.
Well, whether you hold a bias towards it or not, you're saying today that you can't discuss any of the January 6th stuff because there are pending cases or controversies, even though they've all been pardoned by the president. I'm not sure what case or controversy you're referring to. But nevertheless, you're unwilling to say you recuse yourself from a case or controversy involving Columbia when you specifically weighed in there. How do we reconcile that?
Well, Senator, as I stated in the recusal order that Ranking Member Durbin raised, I indicated that I held no particular bias against.
Well, yeah, that's fine. You can say you hold no particular bias about January 6th, too. I mean, it's easy to say. Your letter demonstrates a very clear bias. I'm not saying that it's an unreasonable bias, but it is a bias. It is a prejudice in favor of one view that would cause people to question your impartiality if that case came before you. That seems to me a stronger, much stronger case for recusal than the one you're making to refuse to answer questions about January 6th. So let me just ask to make sure that I understand the limits of what you're prepared to say. Who won the 2020 election?
Senator, as I indicated in response to questions from Senator Blumenthal, Justice Ketanji Brown Jackson, as a sitting circuit court judge at the time of her nomination, was asked this question in questions to the record.
I'm asking you the question.
Yes, and as a sitting judge, I will tell you that it is not appropriate for a judicial nominee to engage in discussion regarding a matter of political controversy with that.
See, this is completely inconsistent with your involvement in the whole Columbia controversy. Completely inconsistent. Because you involved yourself in that controversy. You went out of your way. Nobody asked you to write that letter. You took this upon yourself to do, to insert yourself into that. But you're saying here, you can't answer a simple question about who won the 2020 election because it would somehow implicate you in controversy. I'm sorry, there's no way to square those two things. Mr. Chairman, I yield back. I just wanted to add on to what Senator Whitehouse was saying. In the Central District of California, we have no U.S. attorney. We have no acting U.S. attorney because the person who was acting, their tenure expired. And to get around the confirmation requirement, they have been made the first assistant U.S. attorney and are presumptively running the office from that post. This is someone who has demonstrated their unfitness for the job by going into grand jury so often. His name is Bill Essayli, and getting a no bill, that is the grand jury refusing an indictment when the bar is only probable cause, that they have taken to calling him No Bill Essayli. It was reported in the LA Times that he was heard shouting at the Justice Department over the phone within earshot of the grand jury, vis-a-vis the Justice Manual's requirement that you don't seek an indictment unless you believe you can prove beyond a reasonable doubt someone's guilt at trial, shouting at the Justice Department over the phone that they can F the Justice Manual. And this is who's left in charge of this office, this very important office. So I just want to acknowledge the concern that—
Don't forget to like, comment, and hit the subscribers button for more political and controversial showdowns.